Okay. All right, let's get started. It turns out that organizing judges can be a little bit like herding cats because they have a lot of fans out there. So just to make the suspense rise in here for what will be a wonderful, wonderful event. And so I want to give a very warm welcome to everybody here in the room. It is just so great to see you all here, and also to everybody else who is watching on YouTube and following what is sure to be a treat. I would like to begin, I would like for us to begin by acknowledging this land on which the University of Toronto operates. For thousands of years, it has been the traditional land of the Huron-Wendat, the Seneca, and most recently, the Mississaugas of the Credit River. Today, this meeting place is still the home to many Indigenous people from across Turtle Island, and we are grateful to have the opportunity to work on this land. Now, as you will have seen from the program and heard through the grapevine, this year's Moot revolves around police surveillance and the Charter, and we are absolutely thrilled to have here in the Rosalie Abella Moot Court room such a great crowd. We've limited, as you can see, the seating to make sure that people have a little bit of space, and there are spillover classrooms for students to watch the live stream together. And then, as I already said, there is also YouTube. I'd also like to offer a very special welcome to the undergraduate student visitors from the Black Future Lawyers Program. We're really happy to have you here with us tonight, and I hope that you will also enjoy what you're about to see. As always, this Moot is generously sponsored by McCarthy Tétrault. McCarthy's has a long history of supporting our law students, especially in litigation, and we're so pleased to have many of them here with us tonight. Megan Bridges, I want to acknowledge, she's been coaching the Mooters, and Ilyana Stanic has been taking care of logistics. They are both former Grand Mooters, and so many, many thanks to all of the lawyers who support this event. The panel of judges, especially distinguished this year, needs no introduction. All three judges from, or formerly from, the Supreme Court of Canada, the Honourable Justice Rosalie Abella, the Honourable Justice Andromache Karakatsanis, and the Honourable Justice Mahmud Jamal. The Grand Mooters, as you will see, are the top oral advocates in our class: Mackenzie Faulkner, Madeleine Militza Boljević, and Emma Ibraković. The organizers of the Moot are our two student chief justices, Sophie Zhao and Ainslie Pierrynowski. Many thanks, Sophie and Ainslie, and everybody else who's been working so hard to make this happen. I will let them introduce the problem to you now.
Thank you, Dean Brunet, and good evening, everyone. My name is Ainslie Pierrynowski, and together with Sophie Zhao, we are the co-chief justices of the 2021 Grand Moot. We would like to begin by thanking our sponsor, McCarthy Tétrault. This event would not be possible without their generous support and guidance. Now, we would like to provide a brief overview of the problem that the Mooters will be arguing tonight. This problem is an appeal addressing the constitutionality of certain police surveillance practices. It explores the extent to which condominium residents possess a reasonable expectation of privacy in common areas. It also examines the tension between individual liberties and public safety. The problem takes place in Faulkner, which is a common law province in the country of Flavel. The capital and largest city of Faulkner, Somerville, is a city of approximately 3 million people. The Constitution, judicial system, statutory and common law, and social and political history of Flavel and Faulkner are identical to those of Canada and Ontario, respectively. In terms of the events leading to this appeal, 2 bullets suddenly shattered the window of Dr. Cusick's apartment in Somerville. The police began an investigation into the shooting. A series of tips led the police to focus on one Matthew Josky and his associates, Louis Abdo, Marie Sedis, and Anne Soley. All these individuals lived in Goldfarb condos, a Somerville condominium. This is a small building with extensive security, including cameras inside and outside the building. The cameras record video, have built-in microphones, and allow for night vision.
To continue where Ainslie left off, Detectives Ma and Sue met with Miss Gagnier, the property manager of Goldfarb condos. The detectives requested remote access to the building's security cameras. Miss Gagnier coordinated with the condo's head of maintenance and security to loop the Somerville police into their local network. The detectives would be able to control each camera's angle from their computers at the Somerville police station. Detectives Ma and Shu gathered evidence through both the cameras and naked ear surveillance. The police then obtained a search warrant, allowing them to enter the common areas of Goldfarb condos, as well as Jasky's condo. Upon executing this warrant, the police recovered a firearm of the model that had likely been used to fire the shots into Dr. Cusick's apartment. The police arrested Jasky, Abdo, Soley, and Sedis and charged them with several offenses, including attempted murder. Jasky argued that the camera evidence had been obtained in a manner that violated his rights under Section 8 of the Flavel Charter of Rights and Freedoms. Jasky further contended that this evidence should be excluded under Section 24(2) of the Charter. The Superior Court of Justice admitted the camera evidence and convicted Jasky on all counts. However, the Court of Appeal quashed the conviction and ordered a new trial excluding the camera evidence. The Crown was granted leave to appeal this decision to the Supreme Court of Flavel. On that note, we will now cede the floor to the esteemed justices and our 4 Mooters, Madeleine Andrew G., Mackenzie Faulkner, Emma Ibraković, and Militza Boljević. Thank you.
With your permission, Council, we are satisfied that there are precautions that have been taken and feel comfortable to remove your mask for argument if you prefer. The safety measures make us feel really safe either way, so we'll leave it to you. Let me start by saying I have retired, but I hope never to retire from judging at the Grand Moot. I've been doing this, oh my God, for 20 years, since Rob Pritchard was dean, Mayor Moran, Juan Daniels, who gave me a wonderful Supreme Court present by naming a room after me. I have to tell you, in first-year law school, it never occurred to me that one day there would be a room, so enjoy it. I always feel wonderful to be here, but I also feel like Fred and Spamalot. I'm not dead yet, but I want to tell you, that this law school has always been not only the place that launched me, it was my home. It's where I learned about justice from some of the finest professors in the country. Those lessons have stayed with me forever. Two of the deans are here. Justice Ed Iacobucci's father, Justice Iacobucci, was the judge I replaced on the Supreme Court 17 years ago. His assistant was so unbearably sad at losing him that she called me Justice Abella for about 3 months. So I consider Dean Iacobella part of my family. And Dean Brunet, international law was something that I didn't understand at all, but admired from afar until I read her brilliant articles, those she wrote, especially with Stephen Toop. I think you are really lucky in the leadership that you have in this place. It's always been my experience that it's principled, it's done with integrity, and so to be able to be here in my retiring fashion, to do the Grand Moot now with these outstanding Mooters is really a great honor. So thank you, Dean Brunet, for inviting me. You are going to have the opportunity of watching justice in action with two of my favorite colleagues, one of whom I have never sat with, but loved from the first time I met him. He is a man of extraordinary intelligence, humanity, highly respected. He is the ultimate in the merit appointment. And I have never sat with him. This may be the only time I get to sit with him, but I'm really happy that I will have a chance to sit with you. And Justice Karakatsanis, my sister-in-law, one of the great joys of being on the court for the last 17 years has been the chance to watch, listen with, learn from this incredible jurist and friend, and I will miss her enormously. But I'll be watching your judgments and hope that some of the spirit that some of the damage we did will continue in the years ahead. Anyway, we are here to do a moot, excellent materials, and so let's get to it. For the appellant, the first speaker will be Mackenzie Faulkner.
Thank you. Whenever you're ready.
Go ahead.
Good evening, Justices. My name is Mackenzie Faulkner, and along with my co-counsel, Madeleine Andrew G., I represent the appellant, the Crown, in this matter. The appeal before the court today asks whether the state can be permitted to monitor pre-existing condominium security cameras solely in the common areas of a condo with the express consent of the chair of the condo board. And we say that the charter allows the state to do just that. We have two submissions for the court today. First, that Mr. Jaski's right under Section 8 of the charter was not violated, namely because he did not have a reasonable expectation of privacy, and even if he did, the condo board's consent to the search rendered it constitutionally compliant. Second, if there was a breach of Section 8, the evidence should not be excluded under Section 24(2), because doing so would bring the administration of justice into disrepute. So I'll move now to my submissions on Mr. Jaski's reasonable expectation of privacy. And I want to first make very clear that the subject matter of the search, in our view, is Mr. Jaski's interactions in the common areas with his, at the time, suspected co-conspirators. And he didn't have a reasonable expectation of privacy over this subject matter for two reasons. First, he didn't have a subjective expectation of privacy, and because that comprises a very minor portion of our submissions, unless there are questions on it, we're content leaving that to our written submissions, and instead skipping straight to our bulkier submission, which is that even if there was a subjective expectation of privacy, it was not objectively reasonable. So I'll turn there now, and that begins at paragraph 34 of the appellant factum. And there are two features of the surveillance which I want to highlight here. The first is that it took place only in common areas, and I want to tie that back to the objective factors enumerated in Edwards. And second, that they were monitoring pre-existing cameras, and these recordings would have existed irrespective of police involvement. So I'll start with the common areas. The Supreme Court has made abundantly clear in the Queen and Edwards that an important part of maintaining one's privacy is the ability to exclude others. It is that principle which really forms the foundation of all of the Edwards factors. One's ownership over a property or thing, their ability to control, manage, administer it, their ability to regulate access to it. All of these have a view toward assessing one's capacity to exclude others. And it does so as a means to assess in turn the pervasiveness of the risk that someone might just intrude on your purported sphere of privacy.
Now we're talking about condominium, common area. What do you make of the fact that, as the respondent points out, you can't just walk into the building? It's protected by fob access, and even the appellant couldn't get in without fob access. Doesn't that suggest an element of excluding the public or ability to exclude the public?
It suggests, Justice Abella, an ability to exclude the public on the part of the condo board. That authority has been vested through the Condo Act in the condo board, and it doesn't reside with the individual residents that live there. But to that point, the fact that this took place only within a condominium doesn't make a difference to our analysis. The court in Tesling said that when you knowingly expose information not only to the public at large, but even just to a section of the public, like a condo community, you lose your presumption of a reasonable expectation of privacy. And so the fact that it was only this discrete section of the public that was potentially privy to hearing the things which Mr. Jaski was confiding doesn't make a difference.
I don't want to say it's going to determine the outcome, but so far you've mentioned two cases, Edwards, where I dissented in the Court of Appeal, and Tesling, where my decision in the Court of Appeal was unanimously overturned by the Supreme Court. So I'm wondering, do you have anything else you want to say?
Perhaps you want to use Reeves?
We will be using Reeves and distinguishing it. We rely a great deal on Edwards, so please don't hold your breath as to us moving on from it.
Mr. Faulkner, you're relying on Edwards. Does Edwards detract from Hunter and Salem and the more fundamental principle that Section 8 protects people, not places? Because you're focusing on the common areas, and that seems to me to be inconsistent with Hunter and Salem.
Justice Jamal, it's not inconsistent with Hunter and Southam. So a few points there. First, this has to be at its heart a territorial analysis, and that's because the privacy which attaches to the information divulged in these conversations can't possibly be considered in isolation from the space in which those conversations took place. If Mr. Jaski had a conversation inside of his unit, nobody here would dispute that he was entitled to a heightened expectation of privacy. And yet if he conveyed that exact same information in a crowded restaurant, which is an example the court alluded to in America, or yelling across a crowded room at one another, much less expectation of privacy there. And so really this analysis hinges on the privacy of the territory.
What about an empty gym?
That brings me to my next point, Justice Karakatsanis. We say that a principled approach to Section 8 is that you have a reasonable expectation of privacy in a particular subject matter, in a particular location, and it ought to remain stagnant from there. This is a contextual analysis, but there's a point of precision at which we need to stop. And adopting an ever-fluctuating standard, which is subject to a minute reevaluation, moment by moment, every time a third party leaves or enters the room, isn't a great way. Sorry.
Well, when you're looking at reasonable expectation of privacy, doesn't it matter whether someone's nearby and can overhear you, for example, or whether the room's empty? And you would know before someone approaches?
Well, as I aim to emphasize, what matters is the pervasiveness of the risk, not that the risk actually materializes. It would be a bizarre standard indeed if the police were only able to make use of this evidence if a resident had independently, coincidentally stumbled into that conversation. Our constitutional jurisprudence isn't built on mere happenstance, and an important feature of it is that not only does it affirm our rights, but it provides police with prospective guidance on which they can govern their own conduct. And if we have this ever-fluctuating standard, it doesn't do a great deal to provide them with the consistency that they need and deserve. If we start to take into account the number of people in the room, would somebody working out with headphones count as vitiating the expectation of privacy? Somebody on a loud machine? There are endless variables which would impact this analysis, and so we say that the precision at a certain point has to stop.
Doesn't the case law require you to look at all the variables, look at the totality of the circumstances?
It does, and that's what we are aiming to do by assessing objective reasonableness by reference to and through the lens of Edwards. That is what it is there to do. Now, I think related to something Justice Jamal was getting at earlier are these normative considerations which transcend Edwards. And first, though the court has transitioned into a more normative framework in recent years, we don't view that as extinguishing Edwards or the Edwards factors. Excuse me?
I do.
Yeah. We view them as coexisting. It is one factor of many. And I want to assuage some concerns, hopefully, on the normative part of this. It is not the case that just because you don't have a reasonable expectation of privacy in the conversations you have in public spaces, that now the police have carte blanche to listen in on your conversations whenever they well please. That is one side of the equation. But on the other side of the equation, there were a number of boxes ticked off in this particular investigation. First, there was an ongoing investigation already. There was consent sought and received from the proper channels, which I will, of course, get to soon. And there was a pre-existing camera with pre-existing audio function. And I would suggest that if any one of those boxes was not ticked off in a future search, we'd have a very different case before us.
Can I ask you a factual question?
Please.
I've never heard of an audio security camera. Is this something was that in the contract? Was that in the agreement? Was it in the notice? And I've read the same fact scenario you have.
By our understanding, it was not in the contracts. I imagine an audio security camera is quite rare. That said, that's not the standard we adopt, that they have to reasonably expect the cameras to record audio. Rather, we adopt a principle from Duarte, which I've been alluding to already, which is more of a principle of a reasonable expectation of confidentiality. And what they said in Duarte is that whether a surreptitious recording trenches on a reasonable expectation of privacy turns on whether the person speaking would have reasonably expected their words to have been heard only by those who they were addressing. When you are in a private apartment unit, as they were in Duarte, or a private hotel room, as they were in Wong, it is a fundamentally reasonable expectation that when you speak, your words will be heard only by those who you are speaking to.
Why is it any different in the common areas of a condo? Because that's just an extension of the respondent's home, isn't it? I mean, privacy is at its highest in your home. The common areas of a condo are part of the home.
I would disagree with that premise, Justice. The common areas are not part of a home any more than going to the public gym is part of my home. It is a public space which is there with the specific purpose to accommodate all those who are lawfully inside the building. For the gym and the lobby, that includes not only occupants, but visitors as well. Flowing through the lobby might be landlords, staff. The risk that somebody might hear these conversations and breach the confidentiality of them is quite high in the common areas in a way that it is not high in one's home. I'll move to
Just before you do, the fact that the cameras pick up audio, I mean, you refer to the expectation that nobody will hear you on the one hand, and on the other hand, you rely on the fact that the residents would be aware that there's a camera there. Because it's got the video, the audio, isn't that like picking up private communications between two people. Are we not, does that make a difference? Does that feel a little bit more like wiretapping?
It doesn't feel like wiretapping, Justice, and that's because wiretapping is the interception of private communications. But here, to assert that these are private is conclusory, because what we're asserting is that these were not private at all, because they weren't entitled to a reasonable expectation of privacy. And so that analysis ought to be done first, rather than asserting at the outset that these were private communications. I want to move.
That was a good answer.
Thank you. I appreciate that. I practiced
Doesn't mean
it
you're
quite
right,
hard.
but
I will turn now to our submissions on the cameras and the fact that they were in fact pre-existing. That starts at paragraph 40 of our factum. And I want to emphasize that the distinction between a third party monitoring these recordings and a state monitoring these recordings is especially blurry here. And I rely on two reasons, the first being jurisprudential and the second being germane to the specific facts of this case. So if we look at the jurisprudence, we have seen in Wong an explicit rejection of the kind of Section 8 analysis which operates on the question, would the claimant have reasonably expected their words to have been recorded by the state? That was Justice Lemaire's approach, and it was relegated to a concurrence on that very basis. It is an unworkable standard, respectfully, because the answer to that question is always going to be no. And so that doesn't strike a proportionate balance between the competing interests at play. And rather, we would urge this court to adopt what did prevail in that case, which was Justice Laforet's approach, which was much more broad and general and with respect to society at large. And we've seen that kind of ethos bleeding into Edwards and the cases thereafter. You wouldn't ask justices if a claimant regulated access to his yard from the state agents in particular. You would ask whether he regulates access to his yard at all in determining whether he has a reasonable expectation of privacy in respect of that yard. And so it doesn't much matter whether he thought the state was behind the footage and watching it. It matters that he knew that he was being recorded to begin with.
So the role of the state in using the condo, the property manager and the president of the condo board as opposed to the whole condo board, which is its own issue.
Of course, and I'll move there now.
But isn't the key to the camera issue how we look at the police circumventing their need to get a warrant, which they accepted they had to do, and instead access remotely the cameras of the condo board?
What the police did here was they likely knew that they would need a warrant to install hidden cameras, which is especially intrusive, recording people where they would never expect to be recorded. And they chose a different route, which was to access pre-existing cameras, recording people where they always knew they were being recorded. So they chose a reasonable route here. Now, as for your first point.
Just a second. They knew they would be recorded, but not by the state. Isn't that a difference?
It's not, Justice, for the reasons relating to Wong that I referred to earlier, and for this reason. The very purpose of security cameras, as we all, as reasonable people, appreciate, is to monitor those within its purview and ensure legal compliance by them. And this has to come with the concomitant risk, which again we all reasonably appreciate, which is that if something incriminating or illegal occurs, they can turn that over to the police. And so the police are able to see this footage irrespective. And
isn't that constitutionally significant, though? Because, to go to Justice Abella's point, the reasonable expectation of privacy is a reasonable expectation as against state intrusion. So what may be perfectly benign in the property manager handing over the tapes to the police becomes a problem when it's actually the state that's instigating the recording.
We say it's not a problem, of course, Justice Jamal. And this goes, again, back to the principle in Wong, which is that really we shouldn't be asking whether they would have expected the state to be viewing it, but whether they would expect anybody to be viewing it. Excuse me. And again, I'm sorry.
well, let's talk about Reeves, where a shared owner of a computer knows that the other user of the computer can, in fact, see what's happening. Let's talk about Reeves says control, or as you said, Edwards, the key, the ability to exclude others is at the very heart. But in Reeves, he wasn't even allowed into the home anymore. And the court said that control was not necessary, relevant, but certainly lack of control was not determinative. So it does make a difference whether it's the state or whether it's another person.
So 2 points there, Justice. In this case, the purpose of the security camera, if need be, is to turn it over to the state in order to prosecute that case. That is not the purpose of sharing a computer with one's wife.
So you're saying the purpose of preventing crime is the same as the purpose of gathering incriminating evidence to prove a crime that's committed somewhere else?
That's not what I'm saying.
Okay.
Rather, that anybody can reasonably appreciate the police may see the footage, which is already in the condo board's hands. And so the fact that the police see it first rather than second doesn't strike me as an especially material difference. But to get to your point about control, what Reeves said at paragraph 37 is that shared control doesn't mean no control. And here we have no control. And so it has to be a dominant consideration. With the remainder of my time, sorry.
I love a good argument. So is it really that the police see it first as opposed to seeing it second? Or is it, as Justice Jamal was saying, that it's really about somebody who has the material, chooses to turn it over to the police is one thing, as opposed to the police coming, asking for it, and having a go forward, the ability to control this camera and record everything on a 24/7 cycle for weeks.
There
Is
is
that
no
different?
There is no difference, because in the one case they chose to turn it over to the police, and in the other, through their consent, they chose to do the exact same thing.
So CCTV throughout Canadian cities is now constitutionally permissible, because nobody has a reasonable expectation of privacy when they're on a city street. So that's the sort of state that your argument points towards, does it not?
That's right. And again, there are a number of factors which we would expect would need to be emulated in order for a search like that to be permissible. Namely, that there's an ongoing investigation and that they're not just ensuring blanket compliance by people who walk along that street. And also that the consent be received from the CCTV, which is an important bulwark against the sole discretion of the state, strong-arming private citizens. Now,
Your time is up, sir. Do you want to wrap up?
I will just say thank you for your time, and if you disagree with everything I've said for the last 20 minutes, hopefully my co-counsel will speak to why the evidence should be admitted anyways. Thank you.
Having some difficulties with the wet wipes. Thank you. Sorry for the noise, everyone.
I hope your clock hasn't started yet.
Good evening, Justices. My name is Madeleine, and I will be addressing the appellant's submissions on Section 24(2) of the Charter. Even if this court finds that the respondent's Section 8 rights were violated, the camera evidence should be admitted. Excluding this evidence from the prosecution of an attempted murder would bring the administration of justice into disrepute, and all three of the factors outlined in the Queen and Grant point towards inclusion. First, the police conduct in this case was not serious. Second, the impact on the respondent's rights was only moderate. And third, society's interest in an adjudication of this particular case on its merits weighs strongly in favor of admitting the evidence. And I will address each of the prongs of the Grant test in turn.
Ms. I want to make sure I pronounce it, Andromache.
Correct,
When we get
yeah.
to the third point, would you spend a little bit of time telling me what kind of case society does not have an interest in adjudicating on the merits? It's always struck me as kind of an odd conclusory wrap-up requirement.
Absolutely, Justice Abella, when we get there. I'd like to start first then with the seriousness of the state conduct. And these submissions begin at paragraph 63 of the appellant's factum. Justices, this is simply not a case where this court needs to distance itself from the state's actions. Detectives Ma and Zhao pursued a reasonable course of action which they believed to be lawful by asking for the consent of the chair of the board to access pre-existing visible cameras which only recorded in the common areas. I will address, pardon me, Justice.
I thought the police evidence was that they knew they probably could have gotten a warrant rather than going to the condominium board. Where do we put that in the analysis?
Absolutely, Justice. The police likely knew that they needed a warrant for hidden cameras. But here there is a distinction, and this distinction was supported by the Court of Appeal for Ontario in the case of the Queen and You in 2019. And the distinction here is between, on one hand, knowing that a warrant might have been needed to install hidden cameras, and instead pursuing the reasonable course of action by accessing the visible cameras, and on the other hand, circumventing that law by going ahead and installing hidden cameras instead. And this distinction is important, Justice Abella, because it underlies the fact that the police were not trying to breach Mr. Jaski's rights, and instead they were actually trying to respect them.
By circumventing the requirement to get a warrant, they were respecting his rights?
Justice, when the investigation took place, there was significant legal uncertainty around whether a warrant was needed to access these kinds of cameras. It was not until 2019 where the Court of Appeal for Ontario addressed this issue. And the Supreme Court of Canada has held in multiple cases, including the Queen and Grant, the Queen and Cole, and the Queen and Vu, that legal uncertainty or legal gray areas seriously attenuates any seriousness of the state conduct. And so here, the fact that there was no appellate court guidance that should have let detectives Ma and Zhao know that what they were doing might have been constitutionally questionable should seriously impact our analysis. And in the Queen and Cole, the majority of the Supreme Court of Canada, not the distinguished dissent, found...
Or the judge at the Court of Appeal.
Yes, Justice Karakatsanis, I realize I'm up against two of you here, but in the majority, the Supreme Court of Canada did say that the legal uncertainty between whether a warrant was needed to search an employee's computer, which was owned by an employer, was significant enough to lower the seriousness of the state conduct. And here we have a similarly fine distinction between needing a warrant for a hidden camera and needing a warrant to access pre-existing visible cameras.
Wouldn't that argument have more purchase if the board's approval had actually been given rather than the chair, just the chair of the board?
Justice, it is true that only one of the members of the board, the chair of the board, gave consent, but here it was entirely unworkable for the entire board to give consent because one of the co-accused was on the board. And the Section 24.2 analysis, as we know from the Queen and Grant, is not aimed at punishing police for their conduct. And here the police did not intentionally only go to one member of the board. They were met with a certain circumstances which required them to find reasonable consent, but certainly not the consent of the entire board. And this court is certainly able to set a standard where the entire board will be required to consent in the future.
But the whole board is required under the Occupiers Liability Act for consenting. So the police decided to circumvent the law because one of the members was the former girlfriend of the accused, And so they took it upon themselves, rather than getting a warrant, to just make use of one person, construct the fact that they were obvious cameras and not hidden. So what we're seeing now is a web of rationales for not doing what is lawfully required. That seems to me to be somewhat different from the law is uncertain.
Justice, in this case, the Goldfarb condo bylaws also allowed one member of a board to make decisions about the security of the condominium, including allowing individuals into the space. And so we would ask that that standard be applied here and transferred from the condo board's bylaws onto the facts of this case. And Justice, to address the second part of your question, this was not a pattern or indicative of a pattern of disregard for charter rights. Here, there are at least two circumstances where the police actively tried to respect the respondent's rights. First, when they sought consent, and second,
But they sought consent,
to access the pre-existing cameras
but not from the board,
from the chair of the board.
from a person on the board.
Yes, Justice Abella. And the second time that they showed an attempt to respect Mr. Jaski's rights was when they did seek a warrant for conduct that they knew they needed a warrant for. That was entering the condominium common areas and Mr. Jaski's unit.
Using information they got from these cameras that they had been able to access remotely of questionable legal validity. So they got a legal warrant by using questionable means without telling the judge that that's how they had gotten the information. Isn't that right?
It's true, Justice, that there was an omission, that evidence, the evidence gathered from the cameras was gathered from the cameras in Goldfarb
Forgot to tell
condos.
the judge.
It may have been a mistake, Justice, but this case can be distinguished from cases that establish that omissions in ITOs can increase the seriousness of the state conduct. And we can look to the Queen and White 2015 Court of Appeal for Ontario decision, where the court found that because police had entered a building multiple times before seeking a warrant to continue that exact same conduct, that increased the seriousness of their conduct. But here, no such inference can be drawn that the police should have known what they were doing was constitutionally questionable, using your phrasing, Justice Abella.
Is the fact that the surveillance, the monitoring went on, was round the clock and went on for weeks and weeks, does that go to the seriousness of the police conduct? Does it go to the seriousness of the impact, or both?
Justice, it does not go to the seriousness of the state conduct. It would potentially go to the seriousness of the impact on the respondent's
So
rights.
the duration isn't significant. If there's a breach of charter rights for a fleeting moment, as opposed to a continuous and period of time, you're saying that doesn't go to the seriousness of police conduct?
Absolutely not, Justice. Let me clarify. It doesn't go to the seriousness in this case. And that is because Mr. Jaski was not being recorded or surveilled 24/7 for 3 weeks. The common areas of the condominium were being surveilled 24/7. And so what was being captured were small moments, comings and goings, using gym equipment, but not for particularly long periods of time.
Can I ask, was it his front door that was, it's not clear from the facts whether the camera in the gym actually caught his front door or not?
It could, Justice Karakatsanis, capture his front door. We have no evidence that was gathered. We have no evidence that suggests that anything from his front door was captured. And in fact, it was directly across from the gym.
But they could put together what time he came home, when he left, who came in, a lot of lifestyle choices, right?
Absolutely, Justice, but the Court of Appeal for Ontario in was clear that that kind of information comings and goings when someone gets home is not anywhere near as personal information as, say, the information stored in a personal computer. And so, Justices, I would like to turn to the second branch of the Grant test, the impact on the respondent. And here, the impact was attenuated by several factors. First, any expectation of privacy that Mr. Jaski had in the common areas of Goldfarb condos was extremely low. And second, this evidence, the evidence gathered from the cameras, was likely discoverable absent a charter breach. And so, turning first to the low expectation of privacy that Mr. Jaski had, we know that from the Queen and Grant, that when evidence is gathered from an area, or the evidence is gathered in a way that only infringes on an area where someone has a low expectation of privacy, the impact is attenuated. And here, the Queen and you again said that an individual in a multi-unit building has the highest expectation of privacy in their home, in their unit. As soon as they step out of that door, that expectation of privacy lowers. It does not go away, but that expectation continues to lower the closer an individual gets to a common area, and specifically, the court said, the closer an individual gets to a security camera. Here, Mr. Jaski was recorded both in common areas and in areas that had visible security cameras. And so any expectation of privacy that can be found must be on the extremely low end of the spectrum.
Even accepting that it's extremely low, where does the fact that this was an impingement on an extremely low expectation of privacy of the entire condo population, where does that factor into the analysis?
Certainly, third parties' charter rights can be taken into account, but here we are simply looking at the impact on Mr. Jaski, because Mr. Jaski is the only one who is challenging this evidence. And in fact, there is no evidence on this record that anyone else in the condo was recorded or was, the recordings were saved by the police or used for any criminal purposes.
Would it be relevant as kind of the course of conduct when looking under the first branch, the seriousness of the police conduct?
It could, Justice, but here again, the seriousness is attenuated by the legal uncertainty and the fact that this was not part of a pattern of disregard for charter rights, but certainly it could be in some circumstances taken into account there. I would like to turn to a discussion of discoverability, and these submissions begin at paragraph 75 of the appellant's factum. If evidence could have been discovered absent a charter breach, the Supreme Court of Canada has found that attenuates any impact on a respondent's rights. In the Queen and Cole, the majority of the Supreme Court of Canada held that the fact that police officers had reasonable and probable grounds to seek a warrant to search a computer that was being held by a teacher attenuated the impact on that teacher's rights and led to inclusion of the evidence where the second prong favored that inclusion. And in that case, the court criticized lower courts for not considering discoverability at the second stage. And it is also true that the Supreme Court of Canada has held that impacts can also be attenuated where this information or this evidence could have been gathered in a way that didn't infringe the respondent's rights. For example, in the Queen and Nolay, where the evidence could have been gathered without a charter breach.
And the discoverability here is what? What could have been discoverable?
It is likely that the police could have got a warrant to install hidden cameras or to access the pre-existing cameras. And I would like to address the fact that discoverability can, of course, in some circumstances, cut both ways and be considered under the first prong of the grant test. Our friends mentioned that the fact that this evidence might have been discoverable with a warrant makes the seriousness of the state conduct more intense.
Why ever get a warrant then? If your argument holds, why ever get a warrant?
They could have got a warrant, Justice Jamal, but that does not, should not be a factor when, other than at the second stage, the impact in these particular circumstances. Because in the Queen and Cote, the Supreme Court of Canada told us that the seriousness of state conduct can be increased where a police officer didn't turn their mind to whether a warrant was needed, or where they thought they couldn't get a warrant but continued anyway. And neither of those circumstances are present here. Detectives Manju considered whether they needed a warrant, and without any legal guidance from the courts that would have let them know that their conduct was not charter compliant, they pursued what they believed to be a lawful course in instead accessing the pre-existing cameras. And I would, Justice Abella, like to turn to your question about the third prong of the grant test, the seriousness of the state conduct. Justices, here we are discussing highly reliable and important evidence in the prosecution of a very serious offense. And our friends concede that this evidence is reliable. And so I'd like to talk about the importance of this evidence and the seriousness of illegal firearms charges. Here, the evidence does not need to effectively gut the prosecution for it to be considered important under the grant analysis. In the Queen and You, the fact that the evidence was central to the most serious charges in question was enough for the Court of Appeal to find that it weighed towards inclusion.
What else would they have other than the gun?
Other than the gun, Justice Karakatsanis, there is naked ear and eye surveillance conducted by Detectives Ma and Zhu, which the lower courts ruled was admissible and constitutional. But that evidence, where Detectives Ma and Zhu overheard the respondent say, and I quote, "Nothing more needs to be done, she got the message," is scant evidence for the prosecution of an attempted murder. The camera evidence is the only evidence we have linking Mr. Jaski to First Street and to the gun and his possession of the gun. And Justice Abella, in my conclusion, I would like to just address that, of course, criminal offenses generally are very serious, but appellate courts across this country in recent years have stressed the inherent danger to all of our communities that illegal firearms and gun violence pose. And so that is why we consider illegal firearm charges to be a factor under the third prong of the grant test.
That would mean, contrary, I think, to what the Supreme Court has been saying in recent years, that the seriousness of the offense determines the third factor, and I thought we've moved away from that.
Absolutely, Justice. It should not determine the third factor, nor should it determine the entire Section 24.2 analysis. That is not what the appellant is asking this court to do. We are simply saying that the seriousness of these offenses adds to the already significant weight of admitting this evidence. And in conclusion, the appellant asks that this appeal be allowed, the camera evidence be admitted, and all of Mr. Jaski's convictions be restored. If there are no further questions, those are our submissions. Thank you, Justices.
My name is Militza Boljević, and my co-counsel Emma, Ibraković, and I are here on behalf of the respondent, Mr. Matthew Jaski. Today, my co-counsel and I will establish that the camera evidence obtained in this case violated Mr. Jaski's reasonable expectation of privacy contrary to Section 8 of the Charter, and that the severe police misconduct and impact on Mr. Jaski warrant an exclusion of the evidence. Section 8 guarantees the right to be secure against an unreasonable search. My submissions will address two key components that go towards finding such unreasonableness. First, that the nature of the camera evidence was sufficiently intimate so as to reach Mr. Jaski's biographical core. And second, that the subjective expectation of privacy that Mr. Jaski held was objectively reasonable. My co-counsel will then address why condo board consent to the surveillance was insufficient to authorize the search, and why the grant factors favor exclusion under Section 24(2). Before moving to the nature of the camera evidence and the objective reasonableness of Mr. Jaski's expectation, which will make up the majority of my submissions, I want to briefly touch on his subjective expectation, because my friends raised the court's observations in the Queen and Tesling that when one knowingly exposes information, they can no longer have a subjective expectation of privacy in it. To this we say that if every time somebody is in a space that can be described as public, they can no longer have a subjective expectation of privacy, this would be tantamount to saying that we can only have an expectation of privacy within the confines of our private residence, which simply cannot be the case. A subjective expectation of privacy has always been a low threshold to cross, and it has been crossed in all condo security camera cases. I'll raise an observation from the Queen and Sandhu. There, the court noted that we can infer a subjective expectation of privacy from a lack of behavior modification. That is to say, in this case, Mr. Jaski did not behave as a person would if they had seen a police officer standing at the door, or even a private person who lived in the Goldfarb condos standing at the door. Because we cannot read the mind of any person, when it comes to subjective expectation, we must assume that if they act as a person would believing they are alone, the subjective expectation of privacy is there.
What role do you give to the location? I mean, the argument that's put against you is this isn't a private space at all, and so all of the factors that you're talking about really don't come into play. Whatever his subjective expectation was, how is that possible when you're in a common area with other people?
Justice Abella, we would say that the place plays very little role when we are considering informational privacy as opposed to territorial privacy. Had Mr. Jaski left behind, say, an item in a space, then we would agree it would not have been objectively reasonable for him to assume that nobody could walk by and see that item. But it isn't an item we're talking about here, nor the ability to exclude, rather to who Mr. Jaski chose to communicate information. And he made those choices knowing who was in the space with him. In the Queen and Hassan, which is one of few condo security camera cases, a 2017 Ontario Superior Court case, the court specifically said that in these informational security camera cases, we cannot draw bright lines for geographical locations. And that is precisely what the respondent submits today.
Can I ask you something that's always kind of troubled me when we're talking about subjective expectation of privacy? What role to what extent do we have to look at this from a normative perspective? If I lived in a police state, I might have no subjective expectation of privacy, but would that mean that I ought not to have a privacy interest?
Justice Karakatsanis, I'm glad you raised this. It is always a normative consideration, and should you find that there was little or no subjective expectation, That does not mean that there could not have been an objectively reasonable privacy interest here, and that is something that the court in the Queen and Tesling observed, that we should not place too much emphasis on the subjective expectation. Barring any further questions on the subjective expectation, I will move to my submissions on the biographical core element, which goes to an objective expectation of privacy. Section 8 is meant to protect the information which can be described as each person's biographical core. This is information that reveals intimate details about a person's life and about the choices that they make. And the closer that that information gets to this core, the more reasonable it becomes to find an expectation of privacy.
Are we concerned about criminality, though? You're saying there's a biographical core in making an utterance about your criminal behavior?
Justice Jamal, in every case where we're concerned with Section 8, there will inevitably be some sort of illegal or criminal concern. However, that does not draw away from the biographical core, and in fact, this is an observation that the court in the Queen and Kang Brown made, that information which references illegal conduct or, for example, interaction with a drug dealer can be described as very personal nature.
What do you make of the fact that the Supreme Court, in a decision about garbage in the Patrick case, said that even though it's biographical core information that can be found in the garbage, where that garbage is put outside the home determines the reasonableness of the expectation of privacy. So clearly, where the conversations took place, where the interactions took place, are highly relevant to the reasonableness of the expectation.
Justice Abella, as we speak about biographical core, I'll make the same observation I did earlier, that informational privacy is very different from territorial privacy, which is somewhat how we can consider the garbage. It was placed in a public space and as such was accessible to any person who walked by, and it wasn't even on the person's property. Here, Mr. Jaski did not leave anything behind. He was having a conversation which can be considered much more intimate than garbage which is left in the street.
It actually was on the person's property, but it was slightly beyond the property line, which one could argue is analogous to a common area in a condominium. Not inside the home, but right on the lot line and therefore beyond the lot line. So I don't know how far that argument would get.
Certainly, Justice Abella, but when we are talking about physical items such as garbage, the idea of excluding people, which the court raises in the Queen and Edwards, becomes more relevant than when a conversation is happening in real time and a person can see who is around them and who is observing those conversations. That is something that the court in the Queen and Spencer raised, that we have the ability to control to whom we share information. So we have to assess the space with regards to what the person saw in those circumstances. I do want to...
So you're not taking the position that it was, in fact, an extension of the home?
It certainly can be perceived as such, Justice Karakatsanis. However, if this conversation had taken place in a public gym, as was the example that my friends raised, it wouldn't change our analysis too much in terms of the biographical core element. I do want to discuss the nature of the recording and the camera's features in this case, which contribute to the biographical core and intimate nature of the recording. These submissions begin at paragraph 35 of the Respondent's Factum. In this case, the cameras installed in the Goldfarb condos featured not only video, which has been the case in every other condo security camera case, but it also featured audio, and this audio was discernible within 40 feet of the camera's placement in any given direction. Further, when the condo granted access to the detectives, they also granted them control, meaning that the police could swivel the cameras back and forth depending on whether they needed a better look or a better listen at Mr. Jaski when he was in these areas. When the police obtained access, they had footage rolling for over 3 weeks 24/7. In the Queen and America, Justice McLaughlin noted that when we assess the biographical core of information, we have to be concerned with what the police were really after. In addition to this, she added Justice Cromwell's observations from the Queen and Spencer, that it isn't only the specific information, but all information that can be obtained from it. I want to raise an example that can be distinguished from our case, and that is in the Queen and Tesling. There, Justice Binney noted that the information did not go to a biographical core because not many inferences could be made from that information. There, the technique was heat imaging, how much heat individuals in a house were emitting. That heat could not be tied to one person, and it could not be tied to any activity, so very few inferences could be drawn. Here, we have the opposite situation. We can see Mr. Jaski, we can hear Mr. Jaski, and much more intrusiveness is opened into his life through this medium.
Do you agree that if the condo board had just decided to hand over the tape to the police, your client would have no complaint? Do you agree with that?
We would agree with that, Justice Jamal, yes. The distinction that we make is that which was made in the Queen and America, that there is a difference between communicating information to one person, knowing that they might show that information to the police, and the police actually intercepting your conversations. And that is a distinction that can be drawn here as well.
Well, what would have stopped the police then going every day, or every second day, or every week? I'm thinking of TELUS here, and saying, okay, give us what you got yesterday.
Justice Karakatsanis, if the police were coming in every day to look at this footage, that wouldn't be much more of a different scenario than we have here. In practical terms, it is likely that the condo board would have handed over footage only in situations where they perceived some sort of illegal conduct. Had they, for example, witnessed somebody with a gun in the building, it would have been perfectly reasonable for them to hand over that footage to the police. However, it is not reasonable to assume that every day, as you simply walk around your building, the condo board is handing over that information, and the Queen and you did stress this point. If there are no further questions on the biographical core element, I will move to some other factors which influence the reasonable expectation of privacy, and these are control and Mr. Jaski's potential awareness of the condo cameras in this case. I did touch on control briefly, but I do want to raise it again here with regards to the difference between territorial and informational privacy. Mr. Jaski, at all times, could likely perceive who was around him. If he noted that there was nobody else in these common areas, and he had no knowledge that these cameras had audio components, there was no reason for him to believe that police, or the condo for that matter, could hear him. My friends raised the example that was given in the Queen and America about a crowded restaurant, and that there would be a lowered expectation of privacy in that situation. And we would agree. If a person chose to have what they considered to be a confidential conversation at a relatively loud volume in a crowded restaurant, it may not be objectively reasonable for them to assume that nobody could hear them. However, if that restaurant was empty and they had no knowledge of any audio recording, it would become much more reasonable for them to assume that nobody could hear the information they were communicating except both parties. Mr. Jaski was also a renter in this situation. However, the rental agreement did not mention any audio feature, so he behaved exactly as any other person living in the Goldfarb condos would. He knew that there was likely cameras, he did not know there was audio, and that is how he behaved.
I know that the appellants made something in their material of the fact that he was only an occasional renter in rare, what's it called, rare B&B?
Yes.
And lived there from time to time in different apartments. Is it your position that that's relevant at all to his expectation of privacy, or that his residence there, his lawful residence there, is what gave him the expectation of privacy?
Justice Abella, it is our submission that it's not relevant that he was a rare B&B user in this case. And in fact, despite the fact that he may have been a transient user of rare B&B arrangements, he did use this unit as his private residence. For the time being that he was a rare B&B renter, this was the unit that he lived in. There have been other condo security camera cases, such as in the Queen and Sandu, where the person at question was not even using the unit as a residence, but merely visiting it, and there was still an expectation of privacy. Mr. Jaski did not employ the Goldfarb condos in any way different than that of an owner. And I do want to raise an observation from the Queen in White. There, at paragraph 51, the court said that there is nothing perverse about providing the same level of protection for privacy to those who live in multi-unit dwellings as compared to those who live in single-house residences. Mr. Jaski is no less deserving of privacy than those who live in communities with houses. I'll turn now to Mr. Jaski's awareness of the cameras. The respondent concedes that Mr. Jaski has likely perceived the cameras. They were discernible to the average person and at eye level. However, nowhere in the Goldfarb condos was there a sign that said, "Your conversations are being monitored." They never mentioned there was any audio. The rental agreement didn't mention any audio. And as my friends pointed out and agreed, it is quite rare for cameras to have an audio component, and that is a distinguishing feature in this case. People behave very differently when they believe that they are only being seen, as opposed to when they are being seen and heard. Even if Mr. Jaski knew that the condo was watching him, what he believed was that the condo board or the security person, whoever was monitoring these cameras, could see him walking on the treadmill. That is what he believed the surveillance was doing. He did not believe at any point that even the condo board was listening in on his conversations.
Isn't that argument going to stifle the police's ability to engage new technologies in investigating crime? You're basically saying that the Section 8 analysis is going to be driven off his awareness of the technology that was used.
Not necessarily, Justice Jamal. My friends raised this idea from the Queen and Duarte that we can assess privacy based on whether a person believed they were only communicating information to one other person, and that is what he believed here. Once the police knew that there was an audio component, that does not mean that their investigation had to end. It simply meant that they had to go and get a warrant. There was nothing preventing them from obtaining this new technology. The issue is that no resident was aware that there was an audio component. Had there been signs referencing the audio capabilities of these cameras, this would be a different case, but there was no such indication at any point during the investigation.
So this case would have been different, in your view, if it had been just visual? You would not be able to make the argument that it was objectively reasonable for him to have an expectation of privacy?
Justice Abella, we would contend that there was still an objectively reasonable expectation of privacy, as has been found in other condo security camera cases. However, it is more intrusive in this case because of the audio component. And the information that the police rely on is, for the most part, audio information.
I guess I just want to come back to this question, though, because if, in fact, we follow the argument, all of the electronic all of the new technology that's available for police investigation, I think the logical conclusion of what you're saying is that all of that requires a warrant in advance. That unless it's the old-fashioned knocking on doors and that you just have to get a warrant all the time. And where does that fit in the balance between interest in privacy and law enforcement ability?
Justice, when there is a reasonable expectation of privacy, that means that there will be a warrant necessary. Now, whether it is audio or visual, the expectation of privacy will depend on each of those elements as well as other factors. However, in this case, the police first of all, probably did not know that there was audio component as well. And when they did realize this, they should have realized that this was a more intrusive form of surveillance.
I'm afraid your time is up. Thank you very much for
Thank
your
you.
submissions. Thank you. Ms. Ibraković. You could start by saying you didn't agree with the Supreme Court in Tessling, and you didn't have to say anything else after that.
Perfect. We disagree with the Supreme Court in Tesla.
Fine.
Thank you very much. It's been an
Thank you.
honor.
We'll retire now to consider our decision.
Good evening, Justices.
Was that contempt of court, what I just did?
My co-counsel has already demonstrated that the surreptitious video surveillance at the Goldfarb condos violated Mr. Jaski's reasonable expectation of privacy under Section 8 of the Charter. Now, I will take this court through our two final submissions. First, that the consent of the condo board chair, Ms. Paparousis, could not authorize such a highly intrusive search. And second, that the camera and audio evidence collected and used against Mr. Jaski must be excluded under Section 24(2) of the Charter, as its admission would bring the administration of justice into disrepute. My submissions on consent begin at paragraph 67 of the Respondent's Factum. The Supreme Court of Canada in Wong remarked that citizens in a free and democratic society should be free to go about their daily business without running the risk of being secretly recorded by the state. And that's why Flavellian courts have maintained such robust protections for charter rights since the beginning. But if the only hurdle that prevents police from surreptitiously recording Mr. Jaski at his doorstep is the consent of one condo board chair, then this does not provide robust protections. And in many ways, it provides no protection whatsoever. Condo board consent, or in our case, consent from just one condo board chair, cannot negate the unconstitutionality of such an intrusive and unreasonable search. To take our friend's approach would be to go against the Supreme Court of Canada's jurisprudence on third-party consent and the Ontario Court of Appeals holding in U. It would also have more far-reaching implications for consent in Section 8 more broadly, as well as give the police very broad powers to search people within condo buildings. As a starting point for the consent analysis, Flavellian courts have held that, as a rule, third parties cannot waive other people's rights. In the Queen and Reeves, one Justice Karakatsanis made the great point that a wife could not consent to a search of a computer that she co-owned with her husband. And our friends attempt to distinguish this case by pointing to the fact that the residents here did not co-own the spaces, and nor did they have some sort of exclusive possession. But as Justice Abella highlighted in her dissent in Cole at paragraph 114, property rights do not determine whether a warrant is required. And as the majority held in America, neither is exclusive control. The key point from Reeves, and the one that underlies the idea that the wife could not consent, is the idea that you cannot waive charter rights that are not your own. And this is also, in this case, what our starting point should be when we examine the condo board consent that occurred. In many ways, this case is actually analogous to what happened in Cole. In Cole, an employer school board could not consent to the search and seizure of a laptop that it solely owned, that its employee used, for the same reason. They could not waive another person's charter protections. And in the same way, in this case,
Ms. Paparousis could not consent to such a highly intrusive search. But the respondent's position isn't broadly that condo boards can never cooperate with police. We do understand that there are competing concerns in criminal investigations, and that there are situations where we want condo boards to work together with police. All that we ask is that, given that third-party consent is usually something that is not allowed as a starting point, that we finally curtail the powers of condo boards to consent to such searches. And this conclusion would be in line with the court's holding in Yu. That was another condo board surveillance case from 2019 at the Ontario Court of Appeal. And in that case, the court said that a condo board could consent, for example, to police live entry into a location, but they went beyond the bounds of their authority when they allowed the police to install cameras in that very same building. In fact, what they said in that case was that surreptitious recording cannot be authorized by the board's consent, with no caveat for only in situations where the camera is installed by the police. But what we gather from that case is that consent from a condo board occurs on a spectrum. Some things are allowed, like consenting to police live entry in some cases, but other things, like real-time monitoring through police-installed cameras, are not. And our situation is analogous to what happened in Wong. In both cases, police were watching 24/7, except in our case, it was even more intrusive. Police could, and did in this case, control the angles of the cameras, and in this case, we have audio, which makes it far more intrusive than the kind of search that happened in Yu.
The malleable test you're proposing, how are the police going to know whether they need a warrant then or not? Sometimes it's going to be on-side, sometimes it's going to be off-side.
Right now, all the police have to do is, if they are in a situation of ambiguity, where there has not been a ruling before or no analogous cases, all they have to do is they have to go and obtain a warrant. And they can do that on the phone if it is impractical to do it quickly in person. But the fact is that we do not have to draw a line in this case because the two situations are so analogous. And since it's already a departure from the rule that third parties cannot consent, it should be curtailed this way. In the end, Section 8 is always going to be a contextual inquiry, and the fact that there will be ambiguity in the law like that should not deter us from setting a standard that finally curtails the consent that we give the condo board. There's also something I'd like to touch on that Justice Jamal brought up, and that's about the condo board chair. Our friends said that it would be unworkable for the police in this case to obtain a consent from the full condo board, and that's why they went to just Ms. Paparousis. But the problem here is that police are not entitled to an alternative pathway of consent when their primary mode of consent does not work. For example, if police were to search some of my property, my consent would not be a viable path because I would always say no. But that does not mean that they get to get partial consent simply because that is unavailable to them. In this case, when the police realized that they could not get the consent of the whole condo board, what they should have done is to go and obtain a warrant. And that brings me to my submissions on 24-2. But before I go there, I'd like to make one more point on consent. And that's that the kind of distinction between cameras that are installed by police and those that are pre-existing, a similar distinction has been rejected in the telecommunications context. In the 2013 case of TELUS Communications, Justice Abella, as I'm sure you're familiar with, before you were elevated to the Supreme Court of Laval.
I remember both of my majorities in privacy cases.
In that case, the Supreme Court dealt with a situation where the police wanted to access to a database where TELUS was storing prospective text messages. And what the Crown argued in that case is that a wiretap authorization was not required because the database was already there. That was part of the case. And in that case, the court ruled that that kind of distinction was manifestly unfair because it would draw a distinction between people who knew that there was a database holding their prospective text messages and those who had providers who didn't hold these prospective text messages in a database. And we submit that that kind of distinction is analogous to the case here. And if this court were to uphold you and to go ahead and say that in this case, the consent to pre-existing cameras with audio and control capabilities of the police is also okay, then this will create unworkable jurisprudence, as an even more intrusive kind of surveillance in this case was allowed. So unless there are any further questions on this consent point, I will move to my submissions on the 24-2 analysis.
Is it your position in summary that rather than taking a position of giving the police more latitude when the law is uncertain, or the factual context is uncertain, there should be an automatic requirement of going to get a warrant? Or is it clear from the jurisprudence that they don't have to if the law isn't clear? In other words, I mean, you concede that the condo board has lawful authority to do something that gives the police a kind of access. Not knowing what kind of access is available from that condo board leaves uncertainty. In those circumstances, can the police go ahead anyway, or should they, is it a presumptive fallback, get a warrant no matter what? Because that's not what our jurisprudence has said.
Justice, I'll address your question in a couple different points. The first is that while we do think that the condo boards should be allowed to do something, what we think that they should be allowed to do is that which residents can reasonably expect. And that's exactly what the court said in you, that because the residents could reasonably expect that they could consent to live police entry or some snippets of video footage given to the police after the fact, they would not reasonably expect that a condo board would have the authority to waive their Section 8 charter rights. But I do acknowledge your point that we do give deference to police generally where there is some sort of ambiguity in the law. And this is a point that my friends relied on as well under the first grand factor. But to that, Justice, we say that there are difference in the magnitude of ambiguities that we see in the law. Where there is a big gray area in the law and no analogous sets of facts, yes, perhaps we should give a lot of deference to police, but that is not what happened here. In this case, the police knew that they likely needed a warrant if they were to install cameras. And on top of that, there also was appellate jurisprudence that showed them that there were reasonable expectations of privacy within a condo hallway camera. That was the Queen and White, released in 2015 before the 2016 investigation began. But in addition to that, it was not just that appellate jurisprudence, but also the jurisprudence from Reeves that said and reaffirmed the point in Cole that a third party cannot waive another's rights. And in Reeves, the court actually considered the fact that the police should know that they could not waive, a third party could not waive another person's rights, and considered that to go to exacerbate the misconduct of the police. So in this case, the police cannot rely on that sort of ambiguity in order to rectify their conduct, which in this case was imprudent and is not what we would expect the police to do in these circumstances.
Thank you.
The first grant factor is grounded in this idea that where police act inappropriately, courts should try to distance themselves in order to send the signal that that kind of conduct is not tolerated. And that is especially true where the breach in question is one that is done deliberately or flagrantly. And in this case, there was a deliberate breach by the police. And as Justice Cook put it for the Court of Appeal, this was not a good faith mistake. This was a conscious scheme. And there are 4 different sort of instances we can look to find a pattern of a disregard for charter rights in this case. The first was when the police knew that they likely needed a warrant in order to install new cameras, and they were comfortable simply not doing that and seeking consent in an analogous case. The second was when Ms. Gagné told them that usually the whole board approval was needed, and they were comfortable moving forward with Ms. Paparoussis alone, even though there was no authorization explicitly for her to make that delegated choice in the bylaws or in the Condominium Act. The third was when the police were given control of the cameras after asking for access to the entire network of cameras, just to note. And they noticed that they could control the cameras and that there was audio, and they still did not proceed to get a warrant. In those circumstances, they should have known that audio is far more intrusive and that real-time audio interception of private communications typically requires a wiretap warrant, something that requires more stringent requirements than a general warrant. And yet they did not do anything. And the fourth is when the police left the source of the evidence off on their ITO when they tried to get a warrant to enter Mr. Jaski's home, where they ultimately found the gun. And an analogous situation occurred in the Queen and White. In that case, the police similarly breached the accused charter rights. And when they applied for a search warrant, they left the source of that evidence that was gathered from the breach off. And what the court said in those circumstances is that that exacerbated the police misconduct. The words of the court were, if the police were confident that they had acted in accordance with the law, we would expect them to reveal the source of the information in their ITO. That is especially so in a case like this, where it had been a year and a half with no progression in the investigation until the police finally accessed those pre-existing video cameras. But even if we did earnestly believe the police and give them credit and say perhaps they did think that they did not need a warrant in this case, there were enough red flags along the way and times where they should have turned their minds to getting a warrant and didn't. And as Grant made clear, this kind of ignorance of charter standards or willful blindness cannot be equated with good faith.
But does that mean bad faith? You've said in your factum that they acted in bad faith. Is the fact that you say you can't conclude that they acted in good faith, does that lead necessarily to a finding of bad faith?
Generally speaking, no, Justice. Just because something is not bad faith does not mean it is good faith. There is a spectrum there. What we say in our factum is that the police acted in bad faith when they circumvented the need for a warrant. And that is because in that case, they already likely knew they needed a warrant to install cameras, and they didn't in an analogous situation. And there was appellate case law, both from the Supreme Court and from the Ontario Court of Appeal, that supported that what they should have done is go and obtain a warrant. So in those circumstances, that action was in bad faith, but this court does not need to find that there was an act of bad faith here in order to exclude this evidence. Simply the fact that they did not act in good faith and they were willfully blind to many different issues that came up throughout the way is enough to weigh heavily in favor of exclusion at this first Grant factor. And the second Grant factor also points heavily towards exclusion in this case. The impact of a breach ranges from technical to profoundly intrusive. And as my co-counsel has already stated, Mr. Jaski's expectation of privacy in his private conversations was high. In the Queen and You, the Court of Appeal for Ontario held that surreptitious state recording is highly, if not uniquely, invasive of individual privacy. This is a sentiment that stretches as far back as Wong, but even if we just look at the cases where there was condo board surveillance, this case is far more intrusive than any of those. For example, in the Queen and Hassan, where the evidence was included, there were limited hours of footage. Police could only access the cameras for certain hours a day, certain days of the week, and there certainly was no audio. In the Queen and Pipping, the accused was not the one renting the condo. In the Queen and White, there was serious police misconduct and serious impact, but it was only occasional. The police only went in 3 different times and they were there for a short time. In our case, the police were recording Mr. Jaski 24/7 for a period of almost 3 weeks. And this is far more intrusive than we've seen in other cases. And on this point, Justices, I would like to raise something that was brought up to my friend, and that is this idea of new technology and how it may affect us. At page 44 of Wong, the Supreme Court of Canada held that Section 8 must keep pace with technological developments. And indeed, if we wish to keep Section 8 in pace with technological developments, then we should be adhering to a standard that is normative and not descriptive, as the court said in Tesling. And this kind
Okay, it's almost over.
This kind of approach would mean that just because we happen to be recorded more often nowadays, due to just the prevalence of recording devices, does not mean that our privacy protections should be eroded. And we submit that this would be the correct approach that would be in line with decades of Supreme Court jurisprudence. Finally, I want to turn briefly, in light of my time, to the third Grant factor. Though I will note, Justices, that in the Queen and Lee, the court did say that where the first 2 branches point heavily in favor of exclusion, the third will seldom, if ever, tip the balance. So, Justices, you do not even need to consider the third factor if you don't want to, but in the alternative, there are 2 things here that attenuate the pull towards inclusion. Our friends are right that the evidence is reliable. We don't fight that. And that is simply because this kind of evidence can be paused, replayed as much as the police want, because it is so intrusive. But there are 2 things we should consider here when we look at this pull towards inclusion. The first is that seriousness cuts both ways in the analysis, and the long-term interests of the administration of justice favor the interests of ensuring that Mr. Jaski's rights are respected even where there are serious charges. The second is that in this case, the evidence that we would be excluding would not gut the prosecution's case. And our friends pointed to the Queen and You and said that just like in that case, in this case, the evidence was central, and so this court should follow what happened in You and include the evidence. But in You, it was a slightly different situation because Mr. Sakacha's convictions were entirely reliant on the camera footage, so that entirely gutted the prosecution, and the camera evidence was what the court entirely relied on for the most serious convictions of Mr. Mai, who was the other challenger in that case. So given that, we can distinguish this case. And I will conclude, Justices, by saying that Mr. Jaski's Section 8 rights were violated by the surreptitious video surveillance in Goldfarb condos, and that could not be authorized by Ms. Paparousse's consent. Ultimately, this evidence should be excluded because its admission would bring the administration of justice into disrepute. And I'll leave you with this, Justices. Essential to our idea of a free and democratic society is the freedom to live without fear of police at our doorstep. The price of speaking to another human being or merely leaving the threshold of our homes should not be taking the risk of state surveillance.
Thank you.
Thank you.
The court will retire to consider its decision. Thank you for your submissions, counsel.
Thank you all for attending the 2021 Grand Moot, and thank you to the justices as well as to the Mooters for their hard work. On this note, I would like to introduce Andrew Matheson of our sponsor, McCarthy Tétrault, to say the closing remarks. A slight change of agenda. I may have spoken too soon, so please hold on to that statement for later. Thank you.
So as you know, it is not our job, our assigned job, to make a decision about who is going to win, although I really miss this. You are so lucky to get to do this some more. And you have some law to fix up, you know. I'll give you the list of dissents that you can fix in the next few years. So we will each be speaking to the excellent Mooters, starting with Justice Jamal.
Well, I thought you were all really superb, and you were extremely eloquent. You spoke in complete sentences and paragraphs. You really, no, I mean, a lot of people don't. So, you had a command of the material. You knew the case law. You weren't being thrown off. You answered questions well. You were succinct. And most importantly, you looked like you were enjoying yourselves, and you believed in the positions you were each advancing, even though some arguments were stronger than others. So I think if you want to become advocates, I think you'll be at home in any court in the country. So congratulations, all of you.
I concur. I do want to add that not only did you all look like you were enjoying yourselves, but you made us enjoy ourselves. It was just fun to talk with you and to debate and to discuss. And I was very impressed with all of your poise. You were able to take, no matter what we threw at you, you had sufficient command of your material, that you were agile and able to respond no matter how hard we tried to take you off your track. And it's hard for me, actually, to think of anything that I could have offered by way of constructive criticism. You are all superb, and I look forward to seeing you in the Supreme Court soon.
I was dazzled by the ability of all four of you to take very complicated material. You can tell from the case law that this is an area that the court's been struggling with for a long time. It's every time you get into contextual and factors, you're dealing with really open fields that are there for the picking. And the ability that each of you showed in responding to questions we would have asked counsel in the Supreme Court. We were not patronizing you at all. These were tough questions. Questions we genuinely had based on the material. And every single one of you was able to agree with what the proposition was that you agreed with, and you took us sideways when you wanted us to go sideways, but it was so effective. It was something that I think most advocates can't do until they've been standing in a courtroom for 15 years. So bravo on the intelligence of the arguments and the confidence and the poise, but also, as both of my colleagues have mentioned, it was fun to listen to you because you were clearly enjoying yourselves. You seemed, whatever your stomachs were doing, you didn't seem to be intimidated at all. And we just kind of went with, not these are students, we have to be careful. We reacted to four very good counsel who were making really strong arguments about a very important area of the law. So congratulations to every single one of you and to the people who came up with the Moot. The Book of Authorities was amazing. There were far too many dissents in there, I thought. But brilliant advocacy, and just never lose that joy that you seem to feel in a courtroom today, because judges really listen to the arguments that are good arguments. We want to do the right thing. You want to do the best thing for your client. And that's what the four of you did. You represented your clients very well, and I can't imagine anyone doing it better than the four of you did today. So thank you for the pleasure you gave us. It was an honor to be able to hear your arguments today.
Justice Abella, if you'll indulge me for a moment, speaking of honor, I just wanted to take a moment to say how lucky we all are and how privileged to have participated in this historic Moot. It is the first
case presided over by Justice Jamal since his appointment to the Supreme Court of Canada. He's appeared before me in those seats before, and so I know firsthand what the entire legal community knows, is that he's brilliant, and his qualifications to sit on the highest court of the land are outstanding. So I look forward to many years to come. Well, I've had a decade with Justice Abella, and so this is also very sad for me, because this is also the last time I get to sit and preside with Justice Abella before her time on the Supreme Court of Canada officially comes to an end. She has 6 months to still sign off and so on, so I still consider her with us. And I just think it's very fitting that we're sitting here in the Abella courtroom, because it's really an acknowledgement of her extraordinary contribution, not just to the law here and beyond, but to our everyday lives as Canadians, one of the world's most celebrated jurists. So I just wanted to mark this occasion and to express on behalf of all of us here our deep admiration, our deep gratitude, our deep respect, and our affection for our Rosie. The most senior judge of our sitting court here, I get to do that, hijack your program.
Justices, Mooters, and fans, it's my privilege to deliver quick but important thank yous after this tremendous moot. I'm Andrew Matheson, a partner in the litigation department at McCarthy Tetro. We consider it at our firm a very special honor to sponsor this event, which embodies the best values of education and excellence in advocacy, and we believe deeply in those values. The efforts of many people come together to make this a truly great event and a truly great tradition. The Moot comes together through the work of a lot of people at U of T, on faculty and students, including the Chief Justices, the Grand Moot bench clerks. The fact pattern again this year was brilliant. The citizens of Flavel can be trusted to deliver great, timely legal problems year after year. Mooters, it was humbling to watch your performance today. I judged, I think it was your first run through, and I thought you were awesome then. Today you took it to a different level, and you did so under tougher and wiser questioning. The bench today deserves our deepest gratitude for their generosity in sharing your extremely valuable time in order to make this event so special. It warrants, there's mention of Justice Abella's long affiliation with this tradition. I counted up the times that people have sat on this bench, and Justice Abella is well in the lead, and we look forward to her not retiring that lead. So thank you, each of you. Your very active and enthusiastic participation makes it such a special event. And we have, as a token of appreciation, little gifts for each of you, as well as some gifts for the Mooters.
Gratification. They're not earrings. Ooh. Ooh. That's wonderful. wonderful, thank you. See, now I can take gifts from law firms.
So thank you everyone for making this a tremendous event, and have a great evening.